So the main four structures I'm going to be talking about are the Charitable Trust, Unincorporated Association, Company Limited by Guarantee, and the new Charitable Incorporated Organisation, or CIO. So I'll talk first about the Charitable Trust. This is perhaps the most traditional model for charities. It's quite easy to set up. Its governing document or constitution is a trust deed or a declaration of trust. It has trustees. It has beneficiaries. You may know them as service users in your charity. It's easy to set up, so it's very easy to put together a trust deed. The Charity Commission has some model documents on its website which you can have a look at. And its regulator is the Charity Commission, just the Charity Commission as the regulator. One of the issues with this structure is that there is no separate legal body apart from the trustees themselves, so that any relationship the charity enters into with a third party, perhaps an employment contract or a lease with a landlord of office space, is in reality an arrangement between the trustees personally and the third party, whether it's employee, landlord, or whoever. So let's say that you have some employees, or at least one employee in the charity. That employee may make a claim against the charity. In law, that's a claim by the employee against the charity trustees. Ordinarily, the charity trustees are entitled to be protected against those claims if there are sufficient assets in the charity. That's called being indemnified out of the assets of the charity. But if there were insufficient assets, the charity trustees may have to meet that claim out of their own pockets. So there is this risk of personal liability. And other scenarios where we see this as a problem are things like leases, where the charity may have a lease of an office and there are repair obligations, and what's called a dilapidations claim might be made, and the trustees personally would have to meet those claims if the charity itself didn't have the funds to meet the claim. Another issue with this sort of structure is that if, say, you have a lease and your trustees, one of them might die or retire, you've got a different body of trustees named on the lease to those who are going forward holding the lease. So you may have to change the body of trustees, which in effect means you're transferring the lease from one set of people to another set of people, and you're bound to need landlord's permission or consent to do that. That generally involves some additional cost and administration. So that's another disadvantage of this trust structure.